Harris, there have been cases, we've talked in this hearing about the Wisconsin case that went up to the court involving voting. I think any opinion that I would express, and I don't mean to signal that I disagree with the statement either. What I mean to say is I'm not going to express an opinion because these are very charged issues. They have been litigated in the courts, and so I will not engage on that question.
During his confirmation hearing in 2005, Chief Justice Roberts was asked about the constitutionality of Section 2, which I think you were referring to earlier, of the Voting Rights Act. He testified, quote, "I have no basis for viewing Section 2 as constitutionally suspect, and I don't." Judge Barrett, do you agree that Section 2 of the Voting Rights Act is constitutional?
I think that Chief Justice Roberts' statement, "I have no basis for viewing it as constitutionally suspect," would be the same as mine. I'm not aware of any constitutional law existing that would create a question about it.
Thank you. As Senator Verona mentioned yesterday, in a 2018 case before the Supreme Court, a group of workers were denied overtime pay and joined together to file a lawsuit against their employer. The corporation argued that workers didn't have a right to go to court as a group and could only raise disputes in arbitration individually. Unlike a court proceeding, arbitration is private. The process is hidden from the public and generally cannot be reviewed for fairness by a court. And in many cases, people are forced to agree to arbitration if they want to get the job. In 2018, because of a forced arbitration clause, the workers could not go to a court to fight for overtime and instead were forced to fight for overtime pay behind closed doors in a private arbitration. Justice Ginsburg, in dissent, noted that the workers faced, quote, "a Hobson's choice, accept arbitration or on their employer's terms or give up their jobs." She went on to explain that, quote, "employees must have the capacity to act collectively in order to match their employer's clout in setting terms and conditions of employment." She urged the court to consider the, quote, "extreme imbalance," unquote, "of power in our nation's workplaces and avoid further undermining Congress's passage of labor laws to protect workers and place them on equal footing. Do you recognize Justice Ginsburg's point that there is, quote, "extreme imbalance of power between large corporations and individual workers"?
Senator Harris, I'm going to give you the same answer that I gave you with respect to the sentence that you quoted me from Chief Justice Roberts' opinion in Shelby County, that I'm not going to engage in critiquing or embracing portions of opinions, especially opinions that have been recently decided and are contentious from the court.
And, you've been on the bench a short time, but I'm going to just point out that I do believe, and commentators have noted, a pattern that you've had of ruling against workers and in favor of corporations. For example, in Berlocka v. Contact Transportation Services, you ruled against long-haul truckers seeking overtime pay for additional work. In Wallace v. Grubhub Holdings, you ruled against delivery drivers seeking overtime pay, forcing them out of court and into private arbitration. In Harris v. YRC Worldwide, you ruled against 4 black truck drivers who alleged their employer assigned them less desirable routes when compared to their colleagues. And Smith v. Illinois Department of Transportation, you ruled against a black worker who was called a racial slur by his supervisor. And in fact, if you go on, according to an independent analysis of your decisions, Judge, it appears you have sided with business interest over workers and consumers in about 85% of your business-related cases. Moving on, climate change, as many have mentioned, is an existential threat, and its effects are all around us. In California, we've had 5 of the 6 largest wildfires in the state's history. 31 people have been killed by wildfires in California since August alone, including at least 2 firefighters and a helicopter pilot. Across the state, over 9,000 homes and structures have been burned, and Californians have been forced to breathe dangerous smoke. All of this, obviously, during a pandemic which attacks the respiratory system. But rather than work to combat climate change, the Trump administration has rolled back environmental protections and removed the word the term climate change from government agency websites, including the EPA. In 2007, in Massachusetts versus EPA, the Supreme Court decided by a 5-4 ruling that states could sue the EPA for its failure to combat climate change during the Bush administration. Justice Ginsburg was the crucial fifth vote in that case. Following that ruling, the EPA responded by unequivocally finding that climate change and its impacts are a danger to the public health and welfare. Justice Barrett, yesterday you said that, quote, you have read things about climate change, but you would not say you have firm views on it, unquote. In response to Senator Blumenthal today, you said, quote, you are not competent to opine on what causes global warming, and that you, quote, don't think your views on global warming or climate change are relevant to the work you do as a judge. I certainly do believe your views are relevant, and I'm very concerned about your statements. Since the Massachusetts v. EPA case, scientific consensus has grown even more and stronger that climate change is real, and it is caused by man-made greenhouse gas pollution, and it poses significant threats to human life. If a case that comes before you would require you to consider scientific evidence, my question is, will you defer to scientists and those with expertise in the relevant issues before rendering a judgment?
If a case comes before me involving environmental regulation, I will certainly apply all applicable law, deferring when the law requires me to. And as I'm sure you know, Senator Harris, the Administrative Procedure Act does require courts to defer to agency fact-finding and to agency regulations when they're supported by substantial evidence.
Yes.
So yes, I would apply that law and defer when the law requires me to defer.
And do you accept that COVID-19 is infectious?
I think, yes, I do accept that COVID-19 is infectious. That's something of which I feel like, we could say you take judicial notice of. It's an obvious fact, yes.
Do you accept that smoking causes cancer?
I'm not sure exactly where you're going with this, but, the notice that smoking
It's just a
causes...
question. The question is what it is. You can answer it if you believe yes or no.
Senator Harris, yes, every package of cigarettes warns that smoking causes cancer.
And do you believe that climate change is happening and is threatening the air we breathe and the water we drink?
Senator, again, I was wondering where you were going with that. You have asked me a series of questions that are completely uncontroversial, like whether COVID-19 is infectious, whether smoking causes cancer, and then trying to analogize that to eliciting an opinion on me that is a very contentious matter, opinion from me that is on a very contentious matter of public debate. And I will not do that. I will not express a view on a matter of public policy, especially one that is politically controversial, because that's inconsistent with the judicial role, as I have explained.
Thank you, Judge Barrett, and you've made your point clear that you believe it's a debatable point. Mr. Chairman, these proceedings, I believe, lack legitimacy in the eyes of the people of our country. Americans are right now suffering from a deadly pandemic, and we are also suffering a historic economic crisis. The Senate, in the middle of an election, more than 12 million Americans have already voted. The American people want whomever wins this election to fill this seat. My Republican colleagues know that, I believe. This hearing has done nothing to alleviate the concerns raised about why this nominee was chosen and why this is being rushed when the American people deserve to be heard. So again, I would say, let us not pretend that we don't know what consequences rushing this confirmation will have to the American people. There are countless issues at stake, and to be candid, people are very, very scared. They are scared that allowing President Trump to jam this confirmation through would roll back rights for generations, scared about what it means to the future of voting rights, about what it means for civil rights, for workers' rights, for consumer rights, for climate change, and the right to a safe and legal abortion, not to mention access to health care regardless of income or pre-existing conditions. They are also deeply concerned about what this means for our nation's continued pursuit of the timeless principle, equal justice under law. And I share those concerns. Sadly, my Senate Republican colleagues are doing, I believe, great harm with this illegitimate process. And if they are successful, it has the potential to do great damage. And I believe that damage is to the people of our country and to the United States Supreme Court. Thank you, Mr. Chairman.
Thank you, Senator Harris.